Good morning, everybody, and welcome to follow this panel discussion about practical legal perspectives on international data transfers. My name is Laura Linkomies. I am the editor of Privacy Laws and Business Reports, and I am delighted to be joined today by a fantastic panel to discuss this very tricky topic. So, first to my right is Ruth Boardman. She's a partner at Bird & Bird in London. Welcome, Ruth. Next to her, Laura Brodal, who is an attorney at the Brussels office of Wilson, Sonsini, Goodrich and Rosati. Next to her, we have Diletta De Gico, who is a lawyer in the Cybersecurity, Data and Privacy Department of Steptoe and Johnson here in Brussels. And then to get a company perspective on things, we have a representative from Google, Ludmila Georgieva, who leads on cybersecurity and privacy policy issues at Google's EU team, also here in Brussels. So there have been already one or two sessions on international transfers at this conference, so hopefully we can bring you some different perspectives. Now, we all know that this is a very topical issue. There are developments in the sidelines. We are all waiting for the new EU-US data agreement, which is agreed on the political level, but quite not there yet. So companies have had challenges ever since the famous Schrems II decision, and faced with lots of uncertainty. With the Privacy Shield declared invalid, companies have been increasingly turning to standard contractual clauses. Other opportunities exist. We have binding corporate rules, but they have proven to be very expensive and time-consuming. Would codes of conduct be the answer? They have not been taken up with any great enthusiasm, also very slow to get through with the DPAs. Now, as we know, also the adequacy decisions from European Commission have been few so far. What kind of alternatives should we be looking at? Are there novel approaches, technologies that we could aid for international transfers? What works and what does not? And last but not least, we have had the decision from Austria on Google Analytics, which again makes it more difficult for companies to transfer data to the USA. Now, to hear all these different aspects, we start with Ruth Boardman, who is kindly promised to tell us about the situation in the UK and what's happened there regarding standard contractual clauses. Please, Ruth.
Thanks, Laura. So just to recap, Laura had asked me to bring people up to speed on the recent UK standard contractual clauses, or the UK changes to those. So I'm going to spend a few moments explaining what's been published, why it was needed, and a few points to note if you're not familiar with them. So first of all, as you'll be aware, the Information Commissioner's new agreements were necessary because the new EU Commission approved standard contractual clauses are not acceptable, or weren't acceptable in the UK, because they were published and adopted after the date of Brexit. So they were interesting but of no legal effect for transfers from the UK. However, the UK, just as the EU, had a need to update data transfer agreements to reflect changes in law and to reflect Schrems II, so did the UK. So there was an obvious need to update and to adapt. So earlier this year, the Information Commissioner, using powers under UK legislation, issued two new sets of documents. The first is an addendum to the EU standard contractual clauses. So if you are using the EU clauses as your appropriate safeguard, then you can attach the UK addendum to it, which adapts the clauses for use for UK exported data. And it does obvious things like switching governing law to a law of part of the UK, switching jurisdiction, and ensuring that the Information Commissioner has power to enforce. So that's the addendum. In addition, the Commissioner issued a freestanding data transfer agreement. So if you are looking at transfers from both the UK and the EU, that is of no real use to you because you couldn't use it for the EU part of the transfer. But if you are just looking at transfers from the UK, it could conceivably be of some use. It looks quite different to the EU clauses, but actually there's not really much room for discretion in terms of content. You have to address the same challenges on safeguards in the importing country. You have to impose GDPR obligations. So although it looks different, the substance is really similar. A few points where there are differences. The UK agreement tries to learn from some of the difficulties that have been found with the EU clauses. So there are two key areas where ICO has tried to learn those lessons. The first, of course, with the EU clauses, they can only be used where the importer is not itself subject to GDPR. The UK clauses say it doesn't matter, you can still use them in that situation. It's just that the provisions in the UK clauses which replicate GDPR don't apply in that situation. So they're more flexible in that regard. The second situation, they're more flexible on the constellations of the parties. So you can quite quickly run into scenarios where it's hard to see which module to use of the EU clauses. To give you an example, if you are a processor and you are transferring data, exporting data to another processor who is not your sub-processor, but where you've been asked to do that by your controller, for example, it's not obvious what you do. And the UK clauses are more flexible. You can use them in more constellations. So those are two good points. Pitfalls to note, the UK clauses, so the independent agreement, there is an assumption that there is a separate data processing agreement. So the freestanding EU agreement does not contain controller processor Article 28 language. So it depends on there being a separate commercial agreement which does that. If there isn't, if you have been using EU clauses as your data processing agreement, then you can't just use the UK agreement. There's a gap there that you need to fix. And I suppose the second point to note that you might not expect or be aware of, if you use the UK freestanding agreement, then you have to stipulate a review date as to when you review the provisions in the agreement. That said, I should say that we're seeing very, very few organisations using the freestanding UK agreement. I can only think of sort of less than 5 clients who are using that. Thank you.
Thank you, Ruth. Just when you might all think, oh, I'm now sorted for the UK, of course, this was only for the situation with the EU, isn't that right? The addendum only applies to the EU standard contractual clauses.
Yes, so the UK addendum fits onto the EU clauses, but you could use it more generally.
And I know you also sit in the advisory group for the UK government's data transfer expert panel. Do you have any news to share with us in terms of transfers to third countries?
Sure, so I suppose 2 points there. So first of all, as you'll have seen, the UK is looking at issuing its own adequacy decisions. So top of the list will be US and also South Korea, where the EU decision is not valid in the UK. But the UK has also said that it would like to be able to issue decisions. It's certainly working on them for each of Singapore and Colombia this year. So a divergence there from the EU. As regards transfers more generally, we will have to wait and see what's in the new bill when it's published any day now. The government has said, and DCMS has said, that it wants to both ensure appropriate strong safeguards and that it wants to reduce bureaucracy. So you could say it's motherhood and apple pie. It probably is. We'll have to see how they do that. But I think it's worth emphasising that they really are trying hard on both of those points. So there really is a desire to do this differently and to reduce bureaucracy. But when they say they want to ensure appropriate safeguards, there really is a lot of focus around how they ensure that. So we'll have to see the rabbit when it's pulled out of the hat, but watch that space.
Thank you. Now, I understand there are also situations where standard contractual clauses do not work. So, Diletta, you are going to tell us about that situation and how to overcome it.
Thank you, Laura, and it's a pleasure to be here today. I will be speaking about the nightmare or the paradise of privacy professionals, depending on the point of views, and I will be speaking about standard contractual clauses. We see indeed companies relying more and more on standard contractual clauses. I'm not sure this is based on their own merits. I think it's more related to the lack of real alternatives to the standard contractual clauses. But anyway, we see they are used in the majority of the cases. And we can discuss why later. There are, however, cases where the standard contractual clauses are not the appropriate legal transfer mechanism. I will mainly cover 3 examples. The first one relates to onward transfers and cases where the exporter in the European Union doesn't have enough visibility about onward transfers. The second case relates to transfers that do not survive the data transfer impact assessment, maybe because some of the supplementary measures cannot be applied in practice. And the third example relates to data transfer impact assessment that are based on the so-called risk-based approach, and that might not be an option anymore after the recent developments we saw. So with regard to the first case, there are indeed situations where the data exporter in the European Union does not have control on onward transfers, or is not able, during the due diligence process, for instance, to get enough information, to gather enough information from the data importer about its sub-processors, the subsequent transfers, so the onward transfers that happens after data leave the European Union. And we know that onward transfers need to be covered by the data transfer impact assessment as well. So in these cases, companies might not be able to rely on standard contractual clauses. The second example relates to, as I mentioned, cases where you do not pass the data transfer impact assessment. This might be related to cases where, for instance, the services that the importer provides to the EU exporter needs to be based on access to data in plain text. So some of the supplementary measures that the European Data Protection Board mentioned in its recommendations might not work in practice. The importer outside of the European Union might still be subject to surveillance law, and without those security measures, you do not pass the data transfer impact assessment test. And finally, one case that is supported by recent developments and enforcement strategies and decisions is the one related to the so-called risk-based approach. The risk-based approach actually provided some relief to company after the developments of the Schrems II case. I'm sure that you also took your highlighter and highlighted footnotes 12 of the standard contractual clauses and the DPB recommendation paragraph that mentions that you can actually look at practices. You can look at whether the data importer received any request to access data from data protection authorities when you conduct your data transfer impact assessment. I'm sure I'm not the only one. So there are companies that are relying on a risk-based approach to try to survive the data transfer impact assessment test. Unfortunately, we have seen recent developments where authorities have rejected this type of approach. They clearly mentioned that the risk of access to data from public authorities needs to be eliminated. We cannot speak, there is no room anymore for a reduction of this risk. you are not allowed to look at the likelihood of accessing data, but you need to eliminate the risk to access. So when these cases happens, companies cannot rely on standard contractual clauses. They will not be considered as the appropriate legal transfer mechanism. So what is left? We see in some cases companies trying to achieve data localization, but we know that this is not a real option for many of them. It's a complex exercise, it's time-consuming, is costly. So, and also achieving real data localization is not easy, especially if we consider the broad interpretation of data transfers that has been supported by data protection authorities. Then you have derogations, but we know that derogations are what they are, so they need to be interpreted restrictively. They apply only in certain circumstances. So we don't see companies be willing to rely on those in many occasions. That's why I think that we really need to explore other tools provided by the General Data Protection Regulation, and we need to make progress on those as well. And I think that until that moment come, and I'm of course referring to Code of Conduct, certifications, BCR, until that moment come, probably companies will just be ready to keep relying on the risk-based approach and be ready to defend it in front of a court one day.
Thank you. Some countries outside of the EU are actively promoting the use of standard contractual clauses. Do you see that it could in fact become a global solution?
Thanks for the question, Laura. Indeed, we see discussions at international level at about the global cross-border privacy rules. We have seen a recent announcement of a forum being created among other nations. Then we also have the discussions at OECD level on free flow of data with trust. I think that might be an option. But I also think that we need to think about out of the box. We need to think out of the box. So consider options for data transfers that are more flexible, probably less based on papers, more on common standards. And in that regard, I think it will be interesting to see how these initiatives will develop, and also how will the concept of interoperability that is behind those discussions, so interoperability between privacy frameworks in different regions, will actually interact with the concept of the equivalence that is at the heart of the European Union, which is quite different from interoperability. So I'm not saying that those will not work. I'm just saying that I think they will take time for that.
There is no monitoring process. Is that the main drawback of SCCs?
So I'm not sure I completely agree with the fact that we don't have monitoring process in the SCCs. First of all, they are dynamic. So we have seen that they are actually a framework and that they might evolve. Ruth was mentioning before the fact that the European Commission is now working on the standard contractual clauses that will apply to importers that are already subject to the GDPR. So in that case, companies might have to switch to another set of clauses if their data transfer fall under the new SCCs, if and when they will be published. But also, so it's a framework, is evolving, that you need to monitor. And also, I think we have a sort of peer-to-peer monitoring in the SCCs. We see that due to the recent developments, data exporters need to review the data transfer. They need to be sure that there are no changes in the third country's legal framework that might impact the protection of EU data. But also the data importer is requested to check whether there are any changes in the law and communicate them and notify the data exporter. So I would say there is a sort of monitoring, and also I'm not sure, and I will conclude, I'm not sure it qualifies as a monitoring, but all the enforcement and all the attention we are seeing from Data Protection Authority on standard contractual clauses might even be considered a sort of monitoring.
Thank you very much. Now, moving on, Laura, you're on the hot seat to explain all about adequacy, please.
Yeah, quite literally. It's a bit of a greenhouse in here with all the windows. Thank you, Laura. Laura had asked me to talk about adequacy decisions. So I would start by just recapping what an adequacy decision is. It's a concept in the GDPR whereby the European Commission will deem a non-EU country providing a level of data protection that is essentially equivalent to that what we have in the EU. Where that is the case and the decision is in place, personal data can be transferred from the EU to that country without there being the need to implement further safeguards. Examples of adequacy decisions are Canada, Israel, Japan, the UK. Of course, the hot topic one is the one to the US. So there was an adequacy decision in place that enabled transfers from the EU to the US. It was famously invalidated in 2020 by the Max Schrems decision, the second iteration already of the decision, meaning that currently it is no longer a valid mechanism to transfer personal data from the EU to the US. However, in March of this year, actually 2 months ago to this date, the EU Commission and the US government issued a statement that they had agreed upon an agreement in principle to establish a new transatlantic data privacy framework. The agreement as such has not been made public, but there have been statements and press releases about what the agreement contains. The two key principles are that the US government has committed to introducing limits to data access by national intelligence agencies in the US that will help ensure that any access is proportional and necessary to the aim that they wish to achieve. And the other commitment is that there will be a redress mechanism put in place to enable individuals to actually exercise complaints and have them addressed within the US. As I mentioned, it's an agreement in principle. It's not publicly available. It's currently being translated into legal documentation. Practically, that means that on the US side, they are putting their commitments into what's called an executive order. And then that executive order would be presented to the EU Commission, who would then, on the basis of that order, issue a new adequacy decision. In terms of timing, there's no official statement yet, but we're thinking of, or we've seen indications that it would take only a few more months for the executive order to be issued. Only then will we have a clear sense of what exactly the US commitments entail, because now we have these principles, but a principle can mean a lot of things, especially to lawyers. And then expected after that, it will take a few months for the adequacy decision to be drafted, for the EU Commission to assess the scope of the commitments made, also for the EDPB to weigh in on the scope of the commitments made. So ideally and hopefully, we would have a new adequacy decision by the end of this year.
Those were very reassuring words for many, I'm sure. But what will be different in practice for the organizations taking part when we compare the requirements to the old Privacy Shield?
So the good thing is that even though we, as I said, we don't have the text of the agreement in principle, the US government has in a statement said that actually not that much would change. They've not used those words, but you can derive it from it, in the sense that the self-certification principle, which is the setup of the Privacy Shield, meaning that you as a company, if you want to rely on Privacy Shield for transfers, you declare to the Department of Commerce that you will adhere by the requirements of Privacy Shield, which is putting in place certain obligations and accepting that you can be audited for compliance with them. So that setup, that would remain. So for any companies that are already or that relied on Privacy Shield in the past, the practical framework, the administrative framework will remain the same. There's also been indications that the principles as such, so the requirements to comply with under Privacy Shield would not change. Although, since it's an agreement in principle, we don't know, maybe they will add some few tweaks. We don't know. It's still debated, but there were indications that that would actually quite remain the same in practice. The biggest change is more for the US government, because they have now made commitments to introduce two types of safeguards: proportionality, yeah, I think I'm overusing maybe the word safeguards, provisions that will enable proportionality and necessity to be respected when there is a request for data access, as well as an oversight mechanism internally to make sure that these authorities actually comply with those principles. And on the other hand, introducing some form of legal redress for individuals. Now, I can already hear Laura's question. Is then there nothing that will change for companies? Yes, in the sense that as soon as the executive order would be issued, regardless of its content, it will introduce some safeguards for individuals. So you will be able to update your data transfer impact assessment based on what is in there. So it does mean that even though there may not immediately be an adequacy decision, you will be able to strengthen what you have in place for any transfers ongoing to the US. Then I was going to make another point, Laura, but I don't want to take your time away from questions.
No, please go ahead.
I was going to say then, of course, you may also ask, but how long will it take before this decision to be stricken down again? We have some very bright lawyers, Max and his team, who are raising some very valid and interesting points. The question is, of course, will there be a Schrems III? In the end, the ultimate and literal judge of that will be the courts, the European courts. So whatever is now being put forward, yes, it will be reviewed by the EDPB, it will be reviewed by the Commission. I'm sure there will be many people asking questions, raising concerns, but in the end, it's going to be the court that draws the line and says whether or not this meets the threshold that we expect in the EU. The only thing I can say is, it's a step forward. You know, the executive order in the end will provide safeguards for individuals, which is the core of the GDPR.
Thank you. I appreciate this may be very difficult for you to answer now, not having seen the details of the future agreement, but if there is going to be a legal challenge, which a lot of people say that that's likely, which area do you think it would most likely be targeted at?
I think that in that perspective, the points that are being raised, even though there's no text yet, will be primarily on those two key principles. Do they actually ensure these safeguards, that there is proportionality and that there is an oversight, that is complied with when access requests are being submitted? And is this redress mechanism that may be installed effective in practice? Is it a paper tiger, or is it a real redress mechanism to the standard that we would expect in the EU?
Thank you. Now, next we move on to discuss codes of conduct. Now, recently the EU has adopted its own cloud code of conduct, and Ludmila will tell us Google's perspective on these issues.
Yes, good morning everyone, and thanks a lot, Laura. And first of all, please allow me just to express my absolute excitement being on an all-female impressive panel here. This doesn't happen very often. Apologies for the male audience, but this is our positive discrimination. This is kind of a, but one disclaimer, I have 3 lawyers here, 4 lawyers. I have a legal background, but I am not a legal practitioner, so I always need a bit of a technical support here. And sometimes I might a bit more general than legal. Let's talk about code of conduct. Code of conduct is, of course, one element of the toolkit that we have for data transfers, and could be actually a good element for to allow the data flows. We have the EU Cloud Code of Conduct. It's the first pan-European code of conduct under the GDPR. It's also the first one, of course, for cloud services, and it actually covers obligations for all cloud offerings under the Article 40. Kind of a historical background, it was adopted in 2021 after 4 years of impressive collaboration between the industry, peers, also European Commission and data protection authorities. It was actually adopted kind of following the submission of the Belgian DPA, then it was approved by the EDPB, and then once again followed by a subsequent final approval by the Belgian Data Protection Authority. As I said, the code took about 4 years of discussions. I think they were very meaningful discussions, but it's also worth mentioning that the first step was done by the European Commission, and then the industry took it on. And there was the federation called Scope Europe, which actually facilitated the exercise. There are around 20 to 30 industry companies, corporate members who've been part of the whole exercise. And of course, we've been from very beginning part of the discussions, and there were several good reasons. It is a milestone for the privacy in Europe and for the cloud service providers, but there are several reasons why we actually we were really supportive of this initiative. First, we believe that the code is a great tool for transparency and accountability. It's also, on the one hand, it details data protection best practices for industry, for one industry. It includes, for example, sub-processor policies, portability, also what happens on termination, a kind of security. So it actually makes cloud not anymore, and the privacy in the cloud not anymore a black box, but it's actually, you know what to expect as a customer. On the other hand, it's a tool for a provider to demonstrate compliance under Article 28. And it's also for customers to demonstrate compliance with their own customers, auditors, and regulators. It also assists controllers, and worth mentioning here that cloud acts as a processor, that it assists also controllers to, with technology for responding to data subject access requests. Secondly, there is kind of it helps also to navigate for our cloud customers the compliance journey. We believe that code can really make a difference by facilitating their risk assessment processes. It's also because the work would have been done already for them. And thirdly, we believe that the code is also an effective collaboration instrument among industry and data protection authorities with the Commission, where we can work together to define GDPR requirements in a practical way and also to operationalize them. To give you an example, this is, for example, audits. Under the GDPR, data controllers have unlimited audit rights over processors. So in the cloud context, it's about a few million customers. So it's a bit of it will be great to, and all have the same rights. But granting all of them access to the data centers actually undermines the security of the customers. So in that sense, having the code, it allows actually to operationalize exactly this kind of types. There is a lot of benefits for the customers, as I already mentioned, compliance, to demonstrate compliance, but also it gives, as I said, tools for sub-processors, tools for assistance obligations. For example, when you have, it details the code the code details the assistance requirements expected from cloud service providers, for example, in conducting privacy assessments or when assistance in case of incidents. As I said, data subject rights, it's a great tool as well to handle data subject access requests and delete and other elements. It also gives, the code is validated by the supervisory authorities, which is also already a legal clarity and certainty. And of course, in terms of data protection impact assessment and risk assessment, it's already there. I will make maybe here a bit of a pause. Laura, if you have any questions, otherwise.
I was wondering, you mentioned many positives about codes of conduct, but what are the drawbacks as opposed to SCCs or the other way around? What are the benefits if you compare to SCCs?
So SCCs are more general, and I think the codes of conduct, they allow to really specify on a sector or on a topic. And in that sense, it's kind of also to operationalize GDPR requirements. So I think the question is, as I said at the beginning, it's a toolkit, and you can just choose the toolkit that you actually, in that sense, you can do it for now only for cloud. But in that sense, this allows you really to make it very concrete for for the cloud, for example. You can also apply codes of conduct, and you can think about, I don't know, child safety, or, for example, in finance or insurance, this could be more tailored, rather than SSCs are more general. And I think the question is what you can choose, what you have actually to choose.
The codes can take a long time to negotiate. Do you think it's better to keep them on a more general level or go to very much sort of detail to just make the process quicker?
I think this was the first code, and 4 years was a lot of kind of a lessons learned. But there, I guess when we do it now, like the industry together, it probably with the lessons learned, it will be easier and faster. So I don't think it will take 4 years' time, but it's still a good tool. So I think this is the benefit of having it. It makes really easier to work.
Thank you very much. Now, hopefully the audience has a very good understanding about these instruments that we've discussed, and I'd like to put a few questions to all of the panel before we open up to questions from the audience. We've been asked to discuss novel approaches, so what you would suggest and recommend in terms of other aspects that could be helpful, whether it be sectoral arrangements or technology, multilateral solutions. We've been hearing about the add-on to the ABEC CBPRs. There's not much detail out yet. What do you think? What are the sort of future solutions, if you like? Who would like to jump on this one? Ruth?
So one approach, or complementary approach, I should say, that hasn't been mentioned or that wasn't on your list, Laura, which I think is worth being aware of, is the suggestions being made by the DIFC, Data Protection Commissioner, where they have published what they've called an ethical data management risk index. The idea is that they publish their methodology that you can use to assess different country approaches. And they also propose to publish the results of their own assessments, and they anticipate a sort of colour-coded approach. What I think is really admirable about that is that they are willing to take some of the load themselves. So this is not just saying, well, every exporter go and do this. They're willing to do analysis and to be transparent about that so that you can benefit from their analysis, also so you can see the methodology they've used and decide if it's suitable for you. So it's not a radically different approach, but it does strike me as something which is actually really admirable and really helpful.
Thank you. So that's the Dubai authority, isn't it? Yes, okay. Any other reactions? Ludmila?
Maybe kind of one, what probably is also kind of not mentioning is PCRs. Binding corporate rules is something that actually is also an interesting tool, but I guess a lot of companies just don't take it on it because it's quite lengthy and it's very costly. One element, one solution would be here to have like third-party auditors, not only the DPAs, but actually to be assessed by kind of a third-party auditor. So this could be to facilitate, to make it more faster process, but PCRs are also one of the elements of the toolkit.
Yes, I agree. I think we could almost have another panel about how the process of applying for BCRs could be made quicker at various DPAs. Some are quicker than others and more popular for that reason. Now, as the number of adequacy decisions is limited and we've seen some movement to more data localization, do you think this is a future trend, and where are we seeing evidence of this? Diletta?
Yeah, I can take the question. I can start. I mentioned data localization before as one of the approaches that company can consider when they cannot rely on other legal transfer mechanisms. My experience is that this was a question and an issue that was raised by clients after the Schrems II developments. However, achieving data localization in practice is quite difficult, and it really depends on who you are. If you are a cloud provider, you feel the pressure of your clients and you will probably be able to move your databases to the European Union. But for all other type of companies, it's complex. It's not easy to achieve. In some cases, you might not even have good alternatives in the European Union, and it's really time consuming if that is not your real the core of your business. So my take is that, yes, we have companies considering data localization. I'm not sure this actually happens in practice in many cases. We might see more data localization at the moment in other regions where you really have no choice, such as I'm thinking of the Chinese framework, for instance.
Thank you. Laura?
Yeah, I have to second Dilata's opinion there, because in practice, our economy is global, and there are, as soon as you have a remote access from any of your affiliates outside of the EU, you would already be, in principle, in violation of your data localization safeguard. So it's something that we see being considered in practice, but often very difficult to achieve. And I would also like to add to Ludmila's point on BCRs. There's another benefit to BCRs, is that once you've achieved them, they really enshrine data protection principles in the DNA of a company. Because meeting the BCR threshold and putting them in place means raising awareness, ensuring that your activities are in compliance, and that requires being set across your organization. So that it's not only the benefit of legal certainty, it also helps infuse data protection in the DNA of your company.
But in practice, if I were a company coming to you and saying I need to find a solution, I probably would have to look at a few years to get BCRs adopted, whereas if I wanted to have standard contractual clauses organized, that's probably a lot quicker, wouldn't it?
Practically, yes. I think it also depends on the privacy maturity of your company and what stage you're in. If you're small and developing, maybe you wouldn't be considering BCRs and you would default to SECs because your organization is small and everything is easily managed and you're not necessarily thinking of something large scale. If you're a larger company and your privacy practices are already rather mature, then I think the lengthy piece is the procedural piece and getting them approved by the DPAs.
Thank you. At this point, I would like to open it up for the audience for questions. Do we have some microphones available, please? There's a gentleman right here in the middle. If you can say your name and organization, that would probably help our panelists to address your question. Thank you.
Hi, I am Jorge Garcia. I come from Spain, legal DPO. I wanted to address a very, I think, underlooked document from the Danish authority last February about some guidelines about contracting of data cloud provider services. They opened not one but two options to go with data flows. One was, and I want to quote literally, one was to, if you don't have, if you can maintain that your types of personal data are not in practice subject to surveillance programs, you can go on with them. And the second one was even more suggestive. It's that, oh my God.
I'm very sorry. I'm very sorry, maybe it's just here, but the echo, I don't hear anything. I think our, we don't hear, I don't really understand the question.
We had some difficulty hearing the question about Spanish guidelines and surveillance.
No, not
Can you
Spanish,
please repeat?
but Danish. Now do you hear me? Maybe like that?
I think it's just our...
Okay, like this? Okay. It was so easy. So in February, they published the Danish authorities on guidelines about cloud service contracting. And they opened at the very end of the document two different options. The first one was to keep with your data flows if you were able to sustain that your types of personal data were not in practice, whatever that means, were not subject to surveillance program, okay? And the second one was that even if you thought your data flows were subject to the scope of the surveillance programs, and here they were talking about FISA 702, you could still transfer personal data to your cloud service provider out of Europe without taking any additional action. That for me, the rationale behind that is not a risk-based approach, but the general theory of data, just to sustain or to have legal arguments of whether the FISA 702 or the problematic legislation in each case applies or not to your specific data transfer according to the circumstances. And that is heavily based on Surveillance 2 judgment and all the guidelines from EDPB whatsoever in these last 2 years. And I have no particular individual there to address it. Thank you very much.
I can take the question, Laura, because I was mentioning the risk-based approach before. I think your question is a clear example of probably the fact that we need some clarity on like going forward. We have seen other enforcement authorities taking different stances in that regard. We also see, if we like it or not, companies struggling in using standard contractual clauses and because in some cases, really, you have no choice. Like, if you don't take into account the practices, if you cannot rely on the fact that your data importer maybe has never received an access request, I'm not saying this is the correct approach, but you are left with not many choices. And I think this is why it's important that the DPB task force, for instance, take into account these developments and bring some clarity to the topic, and also that we start using other GDPR tools, because it looks like the SCCs under and with the data transfer impact assessment might not be a real option for the future.
Thank you. Any more comments or questions from the audience? There's a lady here at the front row, please.
Hi, I'm Julian. I'm from a pharmaceutical company. I sold my soul, but I do have a question about the BCRs versus the SCCs. So obviously I'm from a small company, and BCRs, I mean, they're allergic to lawyers in my company, never mind starting bringing this whole GDPR and data privacy, as you would call it, an underdeveloped approach to data privacy. So a gentleman from the EDPB who was on a panel yesterday, when I said to him, you know, going and assessing, you know, all the different jurisdictions that my small company is in, we're in 16 different jurisdictions, assessing those kind of maybe more underdeveloped countries within the EU, it's cost prohibitive, you know, and really small companies are not going to act on that. And his answer was, you risk assess the risk assessment. You know, do you really need to pay lawyers? You know, do you really need to do that? Just kind of go with it. So I got the impression that maybe things weren't to be, this risk assessment could be less formal. So my question to you is, who exactly, or what authorities exactly said, actually we're not really into that risk assessment approach and it needs to be zero tolerance and zero requests? Because maybe it's just my lack of knowledge, but I haven't come across it yet. So it'd be great to get some guidance on that.
Can you repeat the end of the question, please? You're asking who said no. Yeah, I'm referring, for example, to the Austrian DPA recent decision, where they said the risk should be eliminated.
Oh yeah, no, was there anyone else? Are they the only ones that you know of? Are they the only one? Is Austria the only country that you know of taking that approach?
I think that if you also look at the CNIL decision, there are some elements that might lead towards that direction.
Okay. Thank you.
I'm not saying I support this approach, just to be clear.
No, I understand that. I understand. Thank you.
Any more questions? Let's take somebody at the back. Yes. This over there in the middle. Please.
I can probably just take this mic. So as we work on, as I heard, privacy maturity for a while, and we now, I think, do have the clarity that the Court of Justice said twice. I'm always a bit...
Max, sorry, we hear you a bit not very well.
Just going to get this
now
out.
I just spoiled who you are.
Yep, Max Schrems. I'm working on privacy maturity for a longer while. And just a short question, I think we do have the clarity from the Court of Justice, as there's not much where the Court of Justice already issued twice a judgment saying the same thing. I was mainly wondering on solutions. I think the big problem for the small and the average companies is they're not going to solve that puzzle. And that gets kind of to the big companies that need to provide services that are just fully legal and not somehow risk-based, blah, 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 some paperwork. And what's interesting to me is whenever I talk to industry representative, it's basically just really doing the data localization fully is going to be too expensive. Not it's not doable, it's just too expensive to do that, and there's not enough market pressure, so we're just not going to do it. I think to solve any of that in the long run, we would need someone like Google, and you can probably allude a bit to what the internal decisions in such companies are, to actually move data there. It's most of the time physically here already because of latency and so on. The big question is, can we cut the cord in between for at least a lot of the products that do not need all the international data flows, which is a lot of the products. And why is that not done?
Question. So Ludmila, please.
Yes, thank you, Max. It's kind of like, maybe this is the nice thing about lawyers, they agree to disagree. And kind of I think when we talk about risk assessment, our chief legal officer has already stated it publicly in blog posts and in interviews. In particular for Google Analytics, we haven't received any FISA 702 requests in the last 15 years. So there is the question also from the audience here, from the pharmacy industry, exactly on the question of the zero thank you, and risk-based and risk assessment. If the court would have wanted to say that there is no assessment necessary, the court would have said it. The court has actually clearly stated that SECs are a legal tool under the GDPR, and that there is a necessity of adequacy level. Adequacy level doesn't mean absolute, identical, clear, the same, one-to-one. So there is a kind of a room for assessment and for where this exercise needs to be taken. If there is just zero tolerance, then you don't need a impact assessment. But maybe we can continue also our conversation from yesterday outside.
I would have one super short follow-up. The Court of Justice also said that there's a violation of 47, of Article 7 and 8. So the risk assessment was done by the court. It said US law is violating our principles. So that is something that you just can't ignore away. That assessment was done twice. So I don't know where the risk assessment would be in this moment.
I was wondering if the others wanted to comment on this. We've seen a lot of DPA activity on this question. Some are still about to perhaps officially tell us what they think. Others have already given their views. Do you think this is maybe blown out of proportion a little bit? Does anybody want to comment on that?
Maybe I can make one comment back and then also comment on that. So to paraphrase the question, it sounded rather as though you were saying, just do it properly and localize, the rest is so much blah, blah, blah. And it seems to me that actually, for many organizations, saying just do it properly is not trivial. So I think there's an oversimplification there. For many organizations, there really is a need to have support provided out of hours from somewhere, for example, or you could perfectly well have a multinational organization which needs to have one instance of its HR platform, for example. And if everybody says just localize, you can't do that. So I think the question is perhaps an oversimplification. In terms of the comment you made, Laura, about risk-based approach and proportionality, the comment about looking at practice, as Diletta said, is in footnote 12. I don't know, we paraphrase you and say blah, 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 and then you disappear.
I'm super sorry, I really have to be at a meeting, not personal at all. Exactly the opposite, super sorry.
The standard contractual clauses do say you can look at practice. The EDPB recommendations specifically call out the fact that you can consider whether requests are received. So it does seem to me that it is inappropriate, unreasonable, challengeable to then disregard guidelines that authorities themselves have signed off on. At the very least, it's confusing for organisations. And when this is an area that takes up a huge amount of time for people who are really trying to do the right thing, to add to the confusion is not helpful.
Thank you. More questions, please. The gentleman here.
Thank you. My name is Simon Hani. I'm DPO at Uber. I want to get back to adequacy. Japan, bilateral adequacy with Europe. Very interesting notion about bilateral adequacy. If you transfer data from Europe to Japan, it's adequate, so you're off the hook. But if you look at where the data flows, it probably flows through the US. How are we going to deal with that? Or is there an implicit risk-based approach in law? Because we can't say it's risk-free, because the law still exists, which would allow American government or Singapore government at the other side, if the data happens to flow the other way, to intercept the data and at the IP address level, which you cannot encrypt, get hold of it. So how are we going to deal with those kinds of risks? Do we still need to do a transfer impact assessment on flows to adequate countries because they happen to flow through non-adequate countries? Or is that not needed? So what's your view on that? Is there an implicit risk-based approach in the law?
Thank you, Simon. That's a very interesting point. To paraphrase, what I believe you refer to is that data may be transiting through cables that are within the jurisdiction of an authority whose national intelligence agencies may go into those cables and retrieve the data. It's definitely, to use Ruth's words, a questionable situation, as in you can ask questions and on a case-by-case situation, you'll have to assess it. It's a very tricky question, and you'll have I'm trying not to be too overly lawyerly in my response. No, I'm not going to say it depends, because I don't want to be the lawyer that was quoted saying, well, it depends. But I think in that case, especially with transiting and looking at the level of encryption and the technological controls that are being applied, you'd have to also map to identify if that is the case. So for me, it would really come down to a case-by-case assessment. But good question, Simon. I'm saying if you were to look at whether or not there could be an access to data in transit, that as such would be an assessment. I'm not saying necessarily you would need to do transfer impact assessments from one adequate country to another. It's surely an exciting exercise for lawyers. Thank you, Simon.
Thank you. When the UK adequacy agreement was negotiated, I remember onward transfers was one of the tricky items there. Can you tell us something, Ruth, how that was organized?
In what way, Laura?
The transfers through UK, how are we securing now that if you are transferring onwards EU data?
Okay. So at the moment, the UK is applying the same rules as the EU, because EU law has been written into UK law. There were transitional mechanisms that were put in place when the Brexit arrangement was negotiated that sort of required EU data to continue to be protected to EU standards. So that's sort of written into the Brexit arrangements. As a matter of fact, at the moment, as I say, the onward transfer arrangements mirror those that apply in the EU. So at the moment, the question is almost academic because the same principles apply. If and when the UK changes that, which will be, maybe if and when is a bad way of putting it, actually. It's just a question of, is it tomorrow or the day after? But we'll have to see what is in the proposals. Then that is something which will then have to be reassessed and which may potentially impact that decision. Yeah.
Thank you. More questions? Yes, there's a lady here.
My name is Debray Kennedy Mayo. I'm from Georgia Tech in the United States. And China was mentioned on this panel, so I would like to go back to China for just a moment. I'm aware that there has been a report that was commissioned by the EDPB that looked at third countries, particularly China and India, and raised concerns about in a democratic society that is part of the necessary and proportionate standard. So I am curious from the panel if you think there will be, and when that might be, a focus on data flows from the EU to China, and that I'm asking more than just child data flows, as I'm aware that there has been a case related to TikTok. So since the pandemic, China has become the EU's leading trading partner. When we look at data flows that relate to social media and the number of users in the tens of millions, TikTok averages more users than Twitter in the EU, and TikTok has only slightly less than Facebook. And so again, I am curious as to when you think there may be a focus on the government surveillance in China, a non-democratic country. Thank you for your time.
I think you definitely have a point there, and this also relates to the question that Laura was asking before about the focus of enforcement authorities on certain data processing activities. And I think there are 2 points there. If we look at the attention that enforcement authorities are given to certain areas, one is geographic. There is this trend of focusing on the United States, but we know that there are other countries in the world where data are flowing. So I suppose at 12 points, we will need to also look at other regions. But also, I would say the focus on certain type of data processing activities. There is a lot of focus on cookies and data transfers. And someone might wonder whether those are really the most intrusive and the most sensitive data we're transferring outside of Europe, the one transferred with tracking technologies. So I hope that we will see also some enforcement going towards other type of processing activities, probably more intrusive, and also other regions. But I think it was a good step taken by DDPB to publish the report. First, because it gives companies some ideas of how detailed a data transfer impact assessment should be, and it provides guidance. And with that regard, also the annexes, I think, are important in the report, because we know that companies are using questionnaires for their data importers, in many cases, for being able to fill in their data transfer impact assessment, and find some guidelines there, take some inspirations, find some inspirations in the annexes used by the DPB. I think is a positive aspect in this, let's say, area of legal uncertainty.
Yes, the OECD is also starting some work looking into government access to data. There's something definitely to look out for. Any more questions? Yes, gentleman in the middle.
So thank you. I'm a data protection lawyer from My Data Trust. I have 2 questions. First question is regarding Google Analytics. Following the recent development, I heard that, for example, Google was planning Google Analytics 4. What can we expect from that Google Analytics 4?
I'm very sorry, I don't. It's a very bad acoustic here, so I barely hear even my panelists.
Yeah,
so
can you please repeat?
I believe the question was, what is Google Analytics for?
Yeah. What will be the difference between those previous versions that have been invalidated by different DPA in Europe?
I'm happy to share with you. There are several very nice explanations online. What are the different changes? It's kind of changes in the IP, and also, unfortunately, I just need to think about it, but happy to share it with you afterwards. I'll just show you where you can have all the details.
Okay, thank you. The second question is about the SSAs by reference. Some of our clients are, for example, individuals like consultants, and in the contract, sometimes they don't want to, integrate the full European SSS and maybe the UK addendum in the contract because it's too much long. I believe they are maybe lazy to read all those things. And I'm wondering if it is compliant with what the European Commission want when they said, for example, we cannot modify the SSA. They are talking about modifying the content of SSS or the structure, the form into the contract. Thank you.
So I think we as lawyers will all agree on this point. It's about the content, and including by reference does not invalidate the SECs. So I think we can be very brief. Feel free to correct me, anyone, if you think I should not be quoted on this, but.
I apologize, we do have problems hearing you because there's a lot of background noise from the cafe, so when you make your questions, try to speak up a lot. Any questions from the back? No, please put your hands up if there's any. Yes, over here, please, on the side. On that side, please.
Hi, my name is Julie. I work for a large bank. My question is specifically about the controller's obligation to audit processors or sub-processors and the entire value chain of the processors for third country transfer. To what extent we also need to go in and assess the validity of their transfer tool, and also the same obligation for ongoing monitoring. We have thousands of processors, and to say that this is a mammoth task is to put it lightly. So just interested to hear, what is the extent? Is this a 1 and 0 question, legal or not legal? And where does that obligation stem from? Is it Article 28 read in conjunction with Chapter 5?
I would like to approach that. Ruth, please.
Yeah, I think I'll probably reiterate what Diletta said, which is technically the obligation is to keep going and to look at onward transfers. And that's because you said, where does that come from? I would say 3 places. First of all, Schrems 2 says there is a sort of obligation to ensure appropriate safeguards, full stop. So if you're responsible for the transfers and for the processor, then that would extend to that. Secondly, that is stated in the EDPB recommendations. They specifically mention onward transfers. So that's the sort of 1-0 answer, if you like. In terms of a more practical suggestion, then lean on your importers. So many service providers will be recognizing that their clients all have that same problem and will be providing customer-facing packs where they explain these are all the different sub-processors we use. For each sub-processor, this is the data that goes to that sub-processor, this is where they are, this is the analysis we did on the laws in that country, and these are the supplemental measures that we've put in place. And does it completely absolve you? No, but it does provide a very practical approach to the challenge.
Maybe a last question from the audience, right at the back, please, over there. Right at the back on this side, thank you.
Yeah. Hi, can you hear me? Yeah. So, hi, I'm Javier Ruiz, digital rights consultant. And my question is about the risk assessment in the context of the new developments around digital trade and commitments that many countries, including the UK, are now making to include the free flow of data and quite a restricted, include actually restrictions on the type of restrictions that they can put on data flows potentially in the future, even if they don't kick in immediately. This creates some potential legal insecurity. So my question would be, if you are sending data to a country and that country under, for example, an adequacy agreement like the UK, and that country like the UK is signing a free flow of data agreement with a country like, say, Australia, like happened a few months ago, that is not under adequacy? And at what point do you need to start considering the future risks to data transfers in your assessments? That's it. Or should we leave this just to the government level and wait for them to fix it?
Does anybody want to comment on that? Yes, please. Yeah.
If there's an adequacy decision in place, then you as the organisation rely on the adequacy decision. If someone wants to challenge the adequacy decision, shame that Max Schrems has gone, then that's the route to take. And I would say that's not somehow ignoring your responsibilities. The Court of Justice itself has said we are the body that ought to be taking the decision on this. So I would say that's the route to go.
Thank you. We have the last few minutes left. If you could all take your crystal ball out, how would you see the future of international data transfers? Just 1 minute for each, please. Can you start, please, Ludmila?
Yes, maybe also to answer a bit like what Max asked before that, there is a change now, and I think the efforts that the European Commission and the US government put into the whole negotiation, the changes that we will be seeing, obviously that has been announced, is something that kind of where you see that a transatlantic partner moves forward and tries to answer to the European standards and to the European requests. So I think it's kind of a very inspirational, I would say, moment that actually they both work together as equal partners. And I think the transatlantic data privacy framework, it's something that if all these elements that have been announced are in place, it will really, I bet with someone that they will be stand before court, and it will provide legal certainty because this is what it needs. And I think this is where exactly all these crystal balls, when we don't have, when we say SSCs with risk assessment, which is required under SSCs, but then one of the other regulators says no, but actually zero risk. So this is legal clarity is totally necessary for business, but not only for business, it's also for human rights and for the EU citizens and residents to claim their rights. And I think this is hopefully, and there is a new system in place with all these changes. So this is my crystal ball.
Thank you. And Diletta?
I will be brief and second what Ludmila just said. And I really hope and I think at some point we will move indeed towards legal transfer mechanisms that are more flexible and less paper-based, because I think we can all agree that this is not a solution in the long term. And also, hopefully, as a lawyer and privacy professional, we can start focusing on something else than data transfers.
Thank you. And Laura?
I think I can second everything that was said. I would say for transfers, we are developing towards more safeguards and towards solutions for the market, and I think that's what it all comes down to.
And finally, Ruth.
Okay, so first of all, yes, definitely keen to focus on things that are not just transfer related. It does seem to me that there's almost a twin track. So there's a coalition of the willing, you could call it, or a sort of group who are engaging and are discussing on this. And you might not agree with all of their approaches, but there is a willingness to engage. And then separately, there are many other countries or parts of the world where there is no willingness to engage on that. So I think there's a risk of sort of fragmentation in approach there, or twin tracks. I think the question on China, for example, was spot on for that.
Thank you so much to all the panelists for sharing your expertise, and thank you so much for the audience for all your interesting and provocative questions in some places, and I hope you found the session informative. We are finishing just in time, so all that remains me to say is thank you, speakers, and maybe see you next year. Thank you.